We're here today on state's motion to revoke bond filed last week. And I also received and reviewed yesterday Mr. Floyd's response.
Your Honor, the law is clear. It is clear that the trial courts have the power to revoke bond as long as minimum due process is applied. Your Honor, by this hearing, you've given him due process. The trial court has authority to revoke bond if following hearing, the trial court determines that the defendant violates those conditions. It is clear he violated the conditions. The standard of proof in matters initially setting a bond, the state has the burden of proving by a preponderance of the evidence that the trial court should deny bail to protect the community. Proof by a preponderance simply requires that the evidence show that something is more likely true than not. Condition 5, he shall perform no act to intimidate any person known to him to be a co-defendant or a witness in this case, or to otherwise obstruct the administration of justice.
Fulton County District Attorney Fani Willis argued passionately that the judge in the Georgia election fraud case revoke Trump co-defendant Harrison Floyd's bond. She wanted him slapped back into jail, and she outlined why, because of these posts from Floyd.
We've seen these posts, but certainly contacting the Georgia Secretary of State and Gabriel Sterling and calling them derogatory names is a way of intimidating. Whether it actually intimidated is not the result. It is, was it intended to intimidate? Moving on, he's about to go through some things.
He tags Jenna Ellis. Wow, you're a whole mess, girl. Why don't you stop stealing people's hard-earned money for your defense? You're also lying at Dan Scavino. I guess they don't teach you ethics at Harvard Law anymore. And finally, this sickening one. Floyd's in this case because he intimidated Ruby Freeman and her daughter, Shay Moss. He didn't tag Freeman in this post, but he talks about her. Finally, the judge ruled in favor of Floyd. Why? I don't know. I don't know. Because these posts are clearly designed to intimidate witnesses.
First of all, the defense argument that there was no knowledge that these were potential witnesses. That's not an argument that I'm buying. I think that we can't hide behind a veil of ignorance. I do think that in several instances here, there has been a technical violation of Mr. Floyd's bond, and that communications he made wound up before the eyes and ears of potential witnesses and co-defendants. But not every violation compels revocation.
The judge did rule that Floyd's bond deal needs to be rewritten to make it clear that he can't write posts like these.